Friends, today's lecture is on role of the UN mechanism for promotion and protection of minority rights. Introduction. The basis of human rights is liberal individual right. Members of minority communities have all human rights because they are human. The unique and often marginalized situation of minorities means that in addition, they have minority rights. Minority rights are therefore individual rights that are enjoyed by persons belonging to ethnic, religious and or linguistic minorities. There are various methods for protecting minority rights, but as a universal standard, the United Nations puts in place two different types of mechanisms for the promotion and protection of minority rights and sees that states adopt strategies to safeguard the same. This lecture examines the two types of UN mechanisms and their role and functioning. UN mechanism for promotion and protection of human rights. UN human rights mechanism can be divided into two main categories such as the charter-based bodies and treaty-based bodies. Both categories monitor and ensure respect of human rights. Charter-based bodies have been created using the authority of the UN Charter. They are political bodies and can address issues in any country. On the other hand, treaty-based bodies, known as conventional mechanisms, get their authority from UN human rights treaties. Treaty bodies are considered more effective than charter bodies as they come from legal instruments. However, they can only address issues in states that have accepted the treaty. As far as minority rights are concerned, objective of the United Nations is to promote and protect three pillars of minority rights such as non-discrimination, protection of identity and effective participation using the two UN mechanisms as well as other relevant declarations and internationally recognized treaties. UN legal instruments for promotion and protection of minority rights, the treaty-based bodies. Of the numerous legally binding UN human rights instruments or treaties, a few have minority-specific articles and all have rights that are of relevance to minorities. There are 8 main UN treaties protecting a range of human rights, and for each a monitoring committee is there. They are given below. Number 1, Human Rights Committee or Committee on Civil and Political Rights, known as CCPR. Committee on Economic, Social and Cultural Rights, or otherwise CESCR. Committee on the Elimination of Racial Discrimination, CERD, CERD. Committee on the Elimination of Discrimination Against Women, CEDAW or CEDAW. Committee Against Torture, CAT, CAT. Committee on the Rights of the Child, CRC. Committee on the Protection of Rights of all Migrant Workers and Members of their Families, CMW. Committee on the Rights of Persons with Disabilities, CRPD. Structure of the monitoring bodies. Treaty monitoring bodies are made up of human rights experts from different countries. These experts are nominated by their governments, elected by states party to the treaties for fixed and renewable terms of 4 years. Independent, they do not represent the interests of their states. The number of independent experts in a committee ranges from 10 to 23. Each committee meets either 2 or 3 times a year and the session lasts 3 to 4 weeks. Main functions of treaty monitoring bodies. The treaty bodies monitor how the treaties are being implemented by state parties. They perform a number of functions that can be grouped under 4 headings. Number 1, reviewing state reports. This is a common function to all treaty monitoring bodies. State parties to human rights treaties are obliged to submit regular reports to the committees. Treaty monitoring bodies are in charge of reviewing state reports. They identify both achievements and failings and make recommendations which the states should implement to ensure they are respecting their international obligations. Number 2, interpreting the treaty. Treaties contain the human rights standards, but the treaty monitoring bodies provide important contributions to interpreting the standards and clarifying legal obligations. To do so, they issue general comments or general recommendations. Different treaty bodies have different names, but the purpose is the same. General comments are guidelines on specific aspects of the treaty. Let us examine a minority-specific example. The CCPR has issued a general comment on Article 27 of the ICCPR relating to minorities. It provides important guidelines on how Article 27 should be interpreted by states. For example, it informs states that they may not deny the existence of minorities within their state in order to avoid implementing Article 27. It also reminds states that minorities do not have to be citizens of the state to benefit from Article 27. Number 3, considering individual complaints. Some of the human rights treaty bodies have provisions for individuals to bring complaints called communications, alleging that their rights have been violated by a state party. States must agree to the treaty body receiving complaints from individuals within their state by becoming party to an optional protocol or explicitly agreeing to be bound by a provision in the treaty. Decisions on communications made by the committees are quasi-judicial, which means they are similar to legal judgment but not legally binding. States should implement the decision so that they comply with their international obligations, but if they fail to do so, there is little the committee can do. Number 4, thematic or general discussions. The treaty monitoring bodies can organize general discussion based on a particular theme or issue of concern. The objective is to promote a deeper understanding of the content and implications of the human rights treaties. These thematic discussions are public and open to NGOs, non-governmental organizations. The outcome of the meetings can help the treaty body draft a new general comment to the treaty. Therefore, NGO participation is both constructive and encouraged. UN political mechanisms for protecting minorities, charter-based bodies. There are 4 main UN political mechanisms for protecting minorities as given below. Number 1, the Human Rights Council. Number 2, the independent expert on minority issues and other special procedures. Number 3, the Forum on Minority Issues. Number 4, the Universal Periodic Review, also known as UPR. The Human Rights Council, HRC, is the highest ranking forum on human rights in the UN system. It is a political body because its members are governments. It meets regularly in Geneva to discuss and pass resolutions on a variety of human rights issues, including minorities. Its strength lies in the fact that participants can raise issues affecting any country in the world, unlike the treaty-based mechanisms, which can only deal with states that have ratified the treaty. However, it is only as effective as its government members allow it to be. Further, debates on critical human rights issues are frequently overshadowed by political considerations and arguments. Number 2, the independent expert on minority issues and the other special procedures. Special procedures is the name given to individuals and groups of individuals who are appointed by the HRC to examine a particular human rights issue or the situation of human rights in a particular country. The titles of individuals appointed to special procedures differ. They can be called special rapporteur, special representative, or independent expert, and sometimes the HRC appoints a working group. Main functions of the special procedures include information gathering, country visits, and communications. Thematic special procedures can address issues related to that theme in any country in the world. Even if a country has not ratified relevant human rights treaties, the special procedures can examine the situation. Moreover, special procedures are usually very open to receiving input from NGOs. However, the recommendations made by the special procedures are not legally binding on governments. The effectiveness of a particular special procedure is dependent on the individual mandate holder. Focus on the independent expert on minority issues. The Human Rights Council passed a resolution that created the post of independent expert on minority issues, IEMI, in 2005. The key elements of the IEMI's mandate are to promote the implementation of the UN Declaration on Minorities, UNDM, identify best practices relating to minorities. To do this, the IEMI cooperates closely with other UN mechanisms and agencies and with NGOs. The IEMI is also involved in the work of the Forum on Minority Issues. The IEMI has undertaken research on a number of pressing issues for minorities such as poverty reduction, development and Millennium Development Goals, denial of citizenship, public participation and country visits. Number 3, the Forum on Minority Issues. Established by the Human Rights Council in 2007, the Forum on Minority Issues is the only UN body dedicated to minorities. It is a subsidiary body of the HRC. The forum performs two functions. It provides a place of discussion between members of minorities, governments, international agencies, NGOs, and the independent expert on minority issues, that is IEMI. The IEMI reports to the HRC on recommendations from the forum on the given theme of each session. The forum is different to other UN meetings. It focuses only on one theme selected by the IEMI each session. All the statements made by participants must be related to the theme of the forum. The HRC appoints someone with experience on the theme of the forum as its chair, and so the chair changes every year. Starting from the year 2008, the forum has addressed the following themes: minorities and the right to education in 2008, minorities and effective political participation in 2009, minorities and effective participation in economic life in 2010, guaranteeing the rights of minority women in 2011, implementation of the Declaration on the Rights of Persons belonging to national or ethnic, religious and linguistic minorities in 2012. Beyond freedom of religion or belief, guaranteeing the rights of religious minorities in 2013, and preventing and addressing violence and atrocity crime targeted against minorities in 2014. One of the greatest strengths of the forum is that it is solely dedicated to the issues of concern to minorities. Thus, it is very open to minority and NGO participation. Moreover, it produces detailed action-oriented recommendations on the theme. It suffers from two weaknesses. First, it meets for only 2 days per year. So, the time given to each speaker is very limited, given that hundreds of people participate in the forum. Over and above, its recommendations are not legally binding, and it relies on NGOs and minority activists to follow up and work for implementation of the recommendations. Number 4, the Universal Periodic Review, UPR. UPR is an examination over a 4-year period of human rights record of all states by the member and observer states of the HRC. 3 documents are prepared which form the basis for the review. Number 1, the state under review submits a report. Number 2, the UPR Secretariat collects all UN documents relating to that state, treaty body, concluding observations, special procedures, documents, etc., and summarizes them in one document. Number 3, NGOs may submit information according to specific guidelines to the Secretariat. The Secretariat summarizes all information received into one document. The 47 member states of the HRC meets as a UPR working group 3 times a year for 2 weeks each time. During each session, they review 16 states. The UPR process consists of 3 steps: reviewing, final stage including NGO involvement, and next review. The most significant strengths of the UPR process is that the UPR process examines every state once every 4 years, whereas examination by treaty bodies depend on the state ratifying the treaty and submitting a report. But we have to remember that it is a political process where states examine each other. Political allegiances and or rivalries may influence the outcome. Conclusion. While the 2 types of UN mechanisms, are appreciated for the promotion and protection of minority rights, it is left to the countries to have different agreements or even comply. Under such circumstances, NGOs play an important role. The openness of treaty monitoring bodies to NGO participation and contribution varies, but NGO involvement strengthens the work of the committees. The most important fact is that the work of the committee is unlikely to have a direct impact domestically without their involvement. Further, NGOs play a vital role in linking the international to the national and grassroots levels to ensure improvements in the lives of minorities. The same applies to charter-based bodies. Minority representatives and minority NGOs are very important, especially to the functioning of the Minority Forum and the UPR process. Moreover, even the special procedures find it useful to receive input from NGOs. Although direct NGO participation is limited, their involvement with the UPR is very important. NGOs can lobby governments either in person or at the session or in writing before it starts to get them ask questions or make recommendations on their issues. Finally, NGOs can use the recommendations in their advocacy and push for them to be implemented. Thank you.